You're talking to a neighbor when you hear screeching tires and a loud thump. Then you hear a scream. You turn and your spouse says, "That man in the car just hit that girl." Admissible or hearsay? Let's talk about that. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Today, we're diving into the Federal Rule of Evidence 8032, known as the excited utterance exception. Keep in mind that while the rule says the declarant need not be available, recent cases have required the ability to confront witnesses under the Sixth Amendment and may disallow excited utterances in criminal cases. The case we discussed today is one where that issue was raised. So before we know if that utterance is admissible, we have to know if this is a civil case or a criminal one. Before we explore the exception, though, let's briefly revisit what hearsay is. Hearsay refers to an out of court statement introduced to prove the truth of the matter asserted. Generally, hearsay is inadmissible in court due to concerns about its reliability. Rule 8032 provides an exception to the hearsay rule for excited utterances. Under the rule, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused is excused from the application of the hearsay rule. The rationale is that statements made during a startling event are less likely to be fabricated as the declarant's capacity for reflection is suspended. Now, the key elements of the excited utterance exception are, as I said earlier, a startling event or condition. There has to be something that's shocking or startling. In fact, one commentator says you can tell an excited utterance because it starts with, "Oh my God," or something to that effect. Stress or excitement. The statement must be made while the declarant is still under the stress of excitement caused by the event, without time for reflection or fabrication. Because if you give somebody time to think about it, a lot of times their viewpoints change if they think that their statement might help or hurt somebody that they want to help or hurt. Excited utterances are admitted in civil cases all the time. Their use in criminal cases, though, is now sort of impaired by Crawford versus Washington. It's a case I've discussed several times in these hearsay videos. Even if the statement is admissible, the court has to determine whether the admission of the statement violates the Confrontation Clause. So even if a statement qualifies as an excited utterance, its admission might still violate the Confrontation Clause because the statement was testimonial. The difference between testimonial statements and statements that are not testimonial is sort of an item by item decision, and it rests with the discretion of the trial court. Now, the Sixth Amendment says in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. The Supreme Court laid the analytical framework for a Confrontation Clause violation when it stated, where testimonial evidence is at issue, however, the Sixth Amendment demands what the common law required: unavailability and a prior opportunity for cross-examination. That's Crawford. Only testimonial statements cause the declarant to be a witness within the meaning of the Confrontation Clause. It is the testimonial character of the statement that separates it from other hearsay that, while subject to traditional limitations upon hearsay evidence, is not subject to the Confrontation Clause. In a Florida case, the courts there said the mere fact that evidence meets the requirements of an exception to the hearsay rule does not necessarily mean it's admissible as evidence. That's State versus Lopez, a 2008 case. In the Lopez case, police officers in Tallahassee were dispatched on a complaint of an assault and kidnapping. Upon arrival, Officer Gaston met Hector Ruiz, the alleged victim, and asked him what happened. Ruiz, who was upset and nervous, blurted out that Mr. Lopez had pointed a gun at him and forced him from his car. Mr. Ruiz told a second officer, Officer Arias, that the gun was still in his car. Officers recovered a .38 caliber Smith & Wesson pistol. Mr. Lopez was detained, given his Miranda rights, and questioned. Mr. Lopez admitted that the .38 was his and that he had hidden the gun when he saw police officers. The state charged Lopez with possession of a firearm by a convicted felon. The victim, Mr. Ruiz, appeared for a discovery deposition and was questioned by the defense. But when the time came for him to show up for trial as the victim, he didn't show up. In fact, the kidnapping charges that had originally been lodged against Mr. Lopez were dismissed as a result of that, so the state pressed for admission of the hearsay statements. The defense moved to exclude the statements Mr. Ruiz made on the scene. The state argued the statements were excited utterances, while the defense argued they were not excited utterances, and any mention or admission of such statements would violate Mr. Lopez's Sixth Amendment confrontation rights. The trial court determined the statements were admissible under the excited utterance hearsay exception. Mr. Lopez was found guilty with the special finding that he was in actual possession of the firearm. In its opinion, the Supreme Court held the statements violated Mr. Lopez's Sixth Amendment rights. In so holding, the Supreme Court determined that the statements were excited utterances, the statements were testimonial, but the defense did not get an opportunity to cross-examine the witnesses. In reaching that holding, it had to overrule prior case law that held that a discovery deposition was adequate cross-examination. In that case, they certainly didn't think that it was. In Davis versus Washington, SCOTUS held that the statements made by the victim to a 9/11 operator during the course of an attack were not testimonial and were therefore admissible because the victim was simply not acting as a witness. She was not testifying. In effect, she was trying to get the police to come to her assistance. But in a companion case, Hammond versus Indiana, which is 547 U.S. 813, a 2006 case, the victim was waiting on the front porch and the assailant was inside when the police arrived. The victim was escorted to a separate room where she was questioned and filled out a complaint affidavit about the incident. The Supreme Court held that the victim's statement in Hammond was testimonial because there was no emergency in progress, and the primary, if not indeed the sole, purpose of the interrogation was to investigate a possible crime. The Supreme Court has illustrated other factors that can be considered when determining whether a statement is testimonial. Whether the declarant was speaking about the events that were currently happening or circumstances that could currently be responded to, as opposed to events that were clearly in the past and could only be investigated and litigated. Whether the declarant was facing an ongoing emergency, describing or seeking help for a current physical danger, and whether the setting of the declarant's statement was a perilous crime scene or a safe location. So if you hear excited utterance in a criminal case and no one brings up the confrontation clause, you'll know that criminal lawyer is asleep at the switch. Let's talk hypotheticals. Imagine a person witnesses a car accident and then immediately exclaims, "That red car ran the red light and hit the blue car." This spontaneous statement, made under the stress of witnessing the accident, could be admissible under Rule 8032. Again, it's happening at the scene, and it might very well meet the tests for both the confrontation clause and the excited utterance. Because it's not testimonial, it's just bang, a sudden exclamation. Consider a scenario where a child runs out of a house screaming, "Uncle Joe hit me." If this statement is made immediately after the incident, while the child is still visibly upset, it may qualify as an excited utterance and be admissible in either a criminal or civil case. But again, the issue of whether the child is available as a witness may come up under the confrontation clause. Now let's look at a case called Michigan versus Bryant. It's 562 U.S. 344. It's a 2011 case. Police officers found Anthony Covington mortally wounded at a gas station. Before dying, Covington told officers that Richard Bryant had shot him at Bryant's house. The issue was whether Covington's statements to the police were admissible under either the excited utterance exception or the dying declaration, and therefore could they be admitted without violating the Confrontation Clause. The U.S. Supreme Court held that Covington's statements were not testimonial and were made to assist police in addressing an ongoing emergency. Therefore, they were admissible under the excited utterance exception and did not violate the Confrontation Clause. The outcome? The court emphasized that the statements were made under the stress of a startling event and were aimed at resolving an ongoing emergency fitting within the excited utterance exception. Now, here are some practical applications of the excited utterance exception. The timing should be made shortly after the startling event or immediately after the startling event. The declarant's condition. Look for signs of stress or excitement, such as crying, shouting, physical agitation, hands to the face, people shaking their heads saying, "I can't believe what I just saw." Things like that. The declarant's condition is going to be at issue. And the content of the statement. The statement has to relate directly to the startling event. So, as you can see, the excited utterances have a lot more problems for the prosecution than they do for a plaintiff in a civil case, because a plaintiff in a civil case isn't subject to the Confrontation Clause. That's only in criminal cases. So it's perfectly appropriate if you are suing the drivers of the red and blue cars to bring up the excited utterance in a civil case, but it might not be appropriate in a criminal case if the declarant was unavailable. That's what I have for you. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.